Good morning and welcome to a regular meeting of a panel of utility commissioners and staff of the Public Utilities Regulatory Authority held today, Wednesday, March 26th, 2025 at 9 a.m. by remote teleconference. My name is Chairman Marissa Gillette. I'm joined virtually today by my colleagues, the commissioners David Arconti and Michael Karen. We have a regular calendar and consent calendar in front of us today. So we will turn first to the regular calendar. The first item is docket number 220701 WI03, the application of Aquarion Water Company of Connecticut for approval of a water infrastructure and conservation adjustment charge. We will turn to Authority Staff Engineer Maria Joule to present the decision for the panel's consideration, please.
Good morning, Chairman Gillette, Commissioners Karen and Arconti. Aquarion Water Company of Connecticut submitted a semi-annual filing report on January 30, 2025. The company requests that the authority designate project numbers 1432 through 1441 and 1448 through 1508 as WIC-eligible projects. The estimated cost of this project is $45,721,075. The authority reviewed those projects and approves them as WIC-eligible projects. Aquarion also seeks cost recovery for 57 completed projects. The projects represent the replacement of 69,603 feet of pipe. The total cost of this project is $34,381,435. The authority reviewed the 57 completed projects and finds that they will benefit customers. Consequently, the total cost of $34,381,435 may be used to calculate the WIC adjustment. The proposed WIC adjustment is 3.93% for all customers except Plainville system customers. The Plainville customers will be charged 4.27%. The WIC adjustment is subject to limitation according to Connecticut General Statute, paragraph 16-262 WI. Specifically, the amount of the WIC charged between general rate case filing shall not exceed 10% of the water company's annual retail water revenues approved in its most recent rate filing and shall not exceed 5% of such revenues for any 12-month period. The proposed WIC adjustment of 3.93% and 4.27% over the 12-month conforms to the 5% and 10% statutory caps. The authority authorizes the company's incremental 1.93% and cumulative WIC surcharge of 3.93% and 4.27%. The company's WIC surcharge will be effective April 1st, 2025. I recommend this decision to the panel. Thank you.
Thank you. Is there a motion?
Madam Chair, move adoption.
Second.
If there are no comments, I will ask Mr. Bumpin to please take the roll.
Commissioner Karen,
Yes.
Commissioner Arconti,
Yes.
Chairman Gillette.
Yes. Thank you. The decision has been adopted. We'll turn next to docket number 230832 WI02, the application of the Connecticut Water Company for a water infrastructure conservation adjustment semi-annual filing report. We'll turn back to Ms. Joule to present the decision for the panel's consideration, please.
Thank you. The Connecticut Water Company submitted a semi-annual filing report on January 28, 2025. The company requests that the authority designate project numbers 588 through 614 as WIC-eligible projects. The estimated cost of this project is $26,950,000. The authority reviews those projects and approves them as WIC-eligible. Connecticut Water also seeks cost recovery for 13 completed projects for a total of $15,702,998. The authority reviewed the 13 completed projects and finds that they will benefit customers. The total cost of $15,702,998 may be used to calculate the WIC adjustment. The proposed incremental WIC adjustment is 1.35% and cumulative surcharge is 4.90%. The WICA adjustment is subject to limitations according to Connecticut General Statute, paragraph 16-262 WI. Specifically, amount of the WICA charge between general rate case filing shall not exceed 10% of the water company's annual retail water revenues approved in its most recent rate filing, and shall not exceed 5% of such revenues for any 12-month period. The proposed WICA adjustment of 4.90% over 12-month period conforms to the 5% and 10% statutory caps. The authority authorizes the company incremental 1.35% and cumulative WICA surcharge of 4.90%. The company's WICA surcharge will be effective April 1st, 2025. I recommend the decision to the panel.
Thank you. Is there a motion?
Madam Chair, move adoption.
And a second.
Thank you. The decision has been regularly moved and seconded. If there are no questions, I'll ask Mr. Bumpin to take the roll.
Commissioner Karen,
Yes.
Commissioner Arconti,
Yes.
Chairman Gillette,
Yes, thank you. The decision has been adopted. We'll turn next to docket number 240607, the application of Zio Infrastructure Holdco LLC for a certificate of public convenience and necessity. We will turn to Authority Staff Attorney Arthur Lefebvre to present the decision for the panel's consideration, please.
Thank you. Good morning, Chairman Gillette, Commissioner Conti, and Commissioner Karen. In the decision dated July 31st, 2024 in this docket, the Public Utilities Regulatory Authority granted the request of Zayo Infrastructure Holdco LLC to operate as a reseller and facilities-based provider of telecommunications services and issued the company a Certificate of Public Convenience and Necessity, or CPCN. By letter dated February 21st, 2025 in this proceeding, the company notified the authority that it requested surrender and cancellation of its CPCN. Since receiving its CPCN, the company has not commenced operations in Connecticut, does not have any telecommunications customers in Connecticut, and no longer plans to provide any telecommunications services to any affiliated or non-affiliated entities or individuals in Connecticut. The company states that because it never commenced provision of services to the public in Connecticut, the public will not be harmed by the cancellation of the CPCN. General Statute Section 16-247G, subsection G, governs the authority's consideration of the company's CPCN revocation request. The company had a right to a hearing by delivering to the authority a written application for a hearing within 20 days from the date of receipt of the proposed final decision. A hearing was not requested, and therefore the company's CPCN is revoked. Authority staff recommends adoption of this decision. Thank you.
Thank you. Is there a motion?
Madam Chair, move adoption.
I will second.
Thank you. The decision has been regularly moved and seconded. If there are no comments, I will ask Mr. Bumpin to please take the roll.
Commissioner Karen,
Yes.
Commissioner Arconti,
Yes.
Chairman Gillette,
Yes, thank you. The decision has been adopted. We'll turn next to docket number 240822, the petition of Alco Finance Limited alleging violations of Connecticut General Statute Section 16243A by the United Illuminating Company. We'll turn to Authority Staff Attorney Patrick Fryer to present the decision for the panel's consideration, please.
Good morning, Chair Gillette, Commissioner Arconti, and Commissioner Karen. On August 20th, 2024, Alco submitted a petition requesting that the authority order UI to negotiate in good faith regarding an agreement for the purchase of energy and capacity pursuant to General Statute Section 16-243A. An evidentiary hearing was held on December 9th, 2024. On February 26, 2025, the authority issued a proposed final decision. An oral argument occurred on March 18th, 2025. The evidence in the record indicates that UI actively engaged in negotiations with the intent of reaching an agreement within the confines of Connecticut's existing PURPA regulatory structure. Alco's dissatisfaction with Connecticut's PURPA regulatory structure or the terms offered by UI are not a basis for finding UI failed to negotiate in good faith. The authority concludes that there is insufficient evidence to find that UI failed to negotiate in good faith. with Alco concerning a contract for the purchase of energy and capacity. As a result, the authority declines to find that UI violated the provisions of General Statute Section 16-243A, subsection D. Therefore, Alco's petition and the relief requested therein is denied. On behalf of authority staff, I respectfully recommend adoption of this decision. Thank you for your time and consideration.
Thank you. Is there a motion?
Madam Chair, move adoption.
I second.
Thank you. The decision has been regularly moved and seconded. If there are no comments, I will ask Mr. Bumpin to please take the roll.
Commissioner Karen,
Yes.
Commissioner Arconti,
Yes.
Chairman Gillette,
Yes, thank you. The decision has been adopted. We will turn next to docket number 240832, the application for approval to install and use an electricity submetering system at 115 Munson Street, New Haven, Connecticut. We'll turn to Authority Staff Attorney Arthur Lefebvre to present the decision for the panel's consideration, please.
Thank you. Winchester Office LLC submitted an application to the Public Utilities Regulatory Authority requesting approval for traditional electric submetering at 115 Munson Street, New Haven, Connecticut. The authority issued a notice of proceeding on September 11th, 2024, delegating review of this matter to its Office of Education, Outreach, and Enforcement pursuant to General Statutes, Section 16-19J. There is no statutory requirement for a hearing. No hearing was requested and none was held. No public comments were received as part of this proceeding. Electric submetering is governed by General Statute Section 16-19 FF, Connecticut Agencies Regulations Sections 16-11-100 et sec, and the requirements established for electric submetering by the authority in the final decision dated August 6, 2014, in docket number 130126, titled PURA Generic Investigation of Electric Submetering, and the final decision dated September 13th, 2023, in docket number 130126, REO 1, PURA Generic Investigation of Electric Submetering, Review and of Application and Processes. Pursuant to Connecticut Agencies Regulations, Section 16-11-55, the authority reviewed the company's application as well as its responses to interrogatories. The company proposed to submeter electricity through two systems, one for HVAC and another for lights and outlets. While the company is eligible to submeter and consents the authority's jurisdiction, the authority finds that the company does not satisfy all the requirements set forth by the authority or the applicable statutes and regulations. In addition, the authority finds that the company engaged in unauthorized submetering of electricity for a minimum of 4 months from June 21st to October 24th, 2023. The company's application is denied. Authority staff recommends adoption of this decision. Thank you.
Thank you. Is there a motion?
Madam Chair, move adoption.
Second.
Thank you. The decision has been regularly moved and seconded. If there are no comments, I will ask Mr. Bumpin to please take the roll.
Commissioner Karen,
Yes.
Commissioner Arconti,
Yes.
Chairman Gillette,
Yes, thank you. The decision has been adopted. The next item on our agenda is docket number 250127, PURA's investigation into interconnection process modifications. We have before us an interim decision. We'll turn to Authority Staff Christopher Arpin to present the interim decision for the panel's consideration, please.
Good morning, Chairman Gillette and Commissioners Karen and Arconti. The interim decision in docket number 250127, PURA investigation into interconnection process modifications, implements 19 consensus recommendations outlined in the 100-day sprint report. Since the Connecticut Interconnection Working Group was established in 2020, numerous interconnection challenges have arisen, particularly during the annual reviews of the state's clean energy programs. To ensure a more efficient resolution process, the authority opted to address these issues collectively rather than individually during annual review proceedings. As a result, the authority issued a procedural order directing stakeholders to resolve outstanding interconnection matters through the Interconnection Working Group. Specifically, the authority tasked the working group with developing an interconnection sprint report to identify and address unresolved issues within a 100-day timeframe. On December 20th, 2024, the interconnection working group submitted its report to the authority, which included a list of 44 proposals considered during the 100-day sprint. Of these, 26 received consensus support, while 18 were not adopted by the interconnection working group. In this interim decision, the authority approves 19 consensus proposals developed during the 100-day sprint. In certain instances, the proposals have been adopted with modification to ensure their effective implementation. However, consensus proposals 5, 7, 8, 11, 12, and 13 remain under review pending additional cost estimates from the EDCs and will be addressed in the final decision scheduled for August 20th, 2025. To illustrate the impact of this interim decision, I will highlight 3 of the adopted consensus proposals. Proposal 1 raises the Level 1 interconnection application threshold for residential projects from 25 kW to 50 kW. This change ensures that larger residential projects are not subjected to longer timelines or more complex review processes intended for commercial projects, improving overall efficiency. Additionally, Proposal 3 establishes expedited interconnection processes for commercial projects less than 500 kW that are co-located with on-site load or served by on-site infrastructure. By creating a distinct interconnection tract for smaller commercial projects, this proposal prevents unnecessary delays caused by studies required for larger scale projects. Proposal 29 requires the EDCs to develop a plan for integrating flexible interconnections, such as smart inverters and other emerging technologies, into the interconnection guidelines by March 15th, 2026. This initiative will help reduce interconnection upgrade costs, expedite timelines, and expand hosting capacity, supporting Connecticut's clean energy goals. The implementation of these 19 consensus proposals will improve interconnection efficiency, reduce processing timelines, and accelerate clean energy deployment, ultimately benefiting all ratepayers. With that, authority staff recommend approval of the interim decision and docket number 250127. Thank you.
Thank you. Is there a motion?
Madam Chair, move adoption.
Second.
Thank you. The interim decision has been regularly moved and seconded. If there are no comments, I will ask Mr. Bumpin to please take the roll.
Commissioner Karen,
Yes.
Commissioner Arconti,
Yes.
Chairman Gillette,
Yes. Thank you. The interim decision has been adopted. The final item on our regular calendar is docket number 250131, the application of Yankee Gas Services Company doing business as Eversource Energy for approval of the issuance of long-term debt. We'll turn to authority staff Guy Novello to present the decision for the panel's consideration, please.
Thank you, Madam Chair, and good morning, Commissioners Arconti and Karen. On January 28th, 2025, Yankee Gas Services Company doing business as Eversource submitted an application pursuant to Connecticut General Statute 1643B, requesting the authority approve issue first mortgage bonds in an aggregate amount not to exceed $360 million through December 31st of 2026. The company requests approval for this issuance of secured first mortgage bonds in the form of one or more series with a maturity ranging from 1 to 30 years and their principal amount of up to $360 million. The exact amount, maturity, terms and conditions, redemption provisions, and coupon rate will be determined at the time of issuance and will depend on the prevailing market conditions. The mortgage bonds will be distributed in the private market, and the coupon rate will be consistent with market rates for instruments of similar maturity and credit ratings at the times of issuance. The mortgage bonds will be issued at various times no later than December 31st, 2026. The company's proposed use of this debt is consistent with Connecticut General Statute 1643B because the debt is for purposes other than paying expenses in the ordinary course of business or for the payment of dividends. The company states that the principal amount of up to $360 million is necessary to fund the company's capital investments, and permissible business needs during the authorization periods. Specifically, the company forecasts that it will incur total capital expenditures of approximately $730 million and will need to refinance long-term debt maturities of up to $165 million. In evaluating a proposed debt issuance, the authority generally considers the transaction fees, terms and conditions of the debt issuance, the coupon rate, and the effective yield, and the overall financial impact on the company. Here, the proposed is a series of future bond issuances and not a specific debt or bond issuance. Therefore, the actual amount, maturity, terms, and conditions and coupon rate are currently unknown and will be subject to prevailing market conditions at the time of issuance. The authority analyzed the effect of the notes on the company's capital structure, cost of capital, and credit rating using current market conditions for the coupon terms and unsecured debt. The company indicated that the issuance will not hinder any future financing or harm the company's financial flexibility. The company is presently rated Baa1 and stable by Moody's and BBB stable by S&P Global Ratings. Based upon the authority's review of the application and the company's details of the transaction, the staff recommends this decision to be approved by the panel. And thank you for your consideration.
Thank you. Is there a motion?
Madam Chair, I move adoption.
And second.
Thank you. The decision has been regularly moved and seconded. There are no comments. I will ask Mr. Bumpin to please take the roll.
Commissioner Karen,
Yes.
Commissioner Arconti,
Yes.
Chairman Gillette,
Yes. Thank you. The decision has been adopted. We'll turn next to the consent calendar on which there are 10 items, and I'll seek a motion, please.
Madam Chair, I would move today's consent calendar.
Second.
Thank you. The consent calendar has been regularly moved and seconded. Mr. Bumpin, please take the roll.
Commissioner Karen,
Yes.
Commissioner Arconti,
Yes.
Chairman Gillette.
Yes. Thank you. The consent calendar has been adopted in full. That brings us to the end of today's regular meeting agenda. We will adjourn and reconvene next Wednesday, April 2nd at 9 a.m. by remote teleconference. Thank you and have a great rest of the day.